10 landmark cases decided by the Supreme Court. 1. In Re Mallare, AM number 533, September 12, 1974. This 1974 case, still cited today, said that in cases where a person needed to elect Filipino citizenship upon reaching the age of majority, the acts of registering to vote and exercising the right of suffrage were enough to show that he elected Filipino citizenship, without need for any formal declaration. The Supreme Court reversed the revocation after finding that Esteban, respondent Florencio Mallare's father, was a Filipino, because his mother was not married to his Chinese father. Furthermore, when Florencio came of age, he registered as a voter and exercised his right of suffrage. The court considered these acts to be enough to show that Mallare had elected Filipino citizenship, without needing any formal declaration on his part. 2. Ynot v. Intermediate Appellate Court GR number 74457, March 20, 1987. This court has declared that while lower courts should observe a becoming modesty in examining constitutional questions, they are nonetheless not prevented from resolving the same whenever warranted, subject only to review by the highest tribunal. We have jurisdiction under the Constitution to review, revise, reverse, modify or affirm on appeal or certiorari, as the law or rules of court may provide, final judgments and orders of lower courts in, among others, all cases involving the constitutionality of certain measures. This simply means that the resolution of such cases may be made in the first instance by these lower courts. 3. United States v. Chong gr no. L 5272, March 19, 1910. Actus non facit reum, nisi mens sit rea. The act itself does not make man guilty unless his intention were so. The Supreme Court held in this case that there is no criminal liability when one commits an offense or act due to honest mistake of facts, provided that it was not due to negligence or bad faith. Such ignorance of the fact is sufficient to negate the particular intent which under the law is an essential element to the crime of murder charged, cancels the presumption of intent, and works for an acquittal. 4. Villavicencio v. Lukban gr no. L 14639, March 25, 1919. Law defines power. No official, no matter how high, is above the law. Lukban committed a grave abuse of discretion by deporting the prostitutes to a new domicile against their will. There is no law expressly authorizing his action. On the contrary, there is a law punishing public officials, not expressly authorized by law or regulation, who compels any person to change his residence. Furthermore, the prostitutes are still, as citizens of the Philippines, entitled to the same rights, as stipulated in the Bill of Rights, as every other citizen. 5. Cayetano v. Monsod gr. number 100113, September 3, 1991. Practice of law is not limited to the conduct of cases or litigation in court. It embraces the preparation of pleadings and other papers incident to actions and special proceedings, the management of such actions and proceedings on behalf of clients before judges and courts, and in addition, conveying. Taking into consideration the modern definition of practice of law and the liberal construction intended by the framers of the Constitution, verily more than satisfy the constitutional requirement that Christian Monsod has been engaged in the practice of law for at least 10 years. 6. Primicias v. Fugoso gr no. L 1800, January 27, 1948. In 1947, the mayor of Manila refused to grant a permit to hold a rally at Plaza Miranda. The Supreme Court said that the mayor's fear that trouble may arise during the rally was not enough reason to suppress the fundamental right of the people to free speech and peaceful assembly to petition the government for redress of grievances. Fear of serious injury cannot alone justify suppression of free speech and assembly. It is the function of speech to free men from the bondage of irrational fears. To justify suppression of free speech, there must be reasonable ground to fear that serious evil will result if free speech is practiced. There must be reasonable ground to believe that the danger apprehended is imminent. There must be reasonable ground to believe that the evil to be prevented is a serious one. The fact that speech is likely to result in some violence or in destruction of property is not enough to justify its suppression. There must be the probability of serious injury to the state. 7. People v. Genosa Gr. No. 1, 35981. January 15, 2004. This case, stemming from a wife's killing of her husband in 1995, is the first to use battered woman syndrome as a defense. The Supreme Court reiterated the principle that aggression, if not continuous, does not warrant self-defense. In the absence of such aggression, there can be no self-defense, complete or incomplete, on the part of the victim. Thus, Marivic's killing of Ben was not completely justified under the circumstances. Appellant Marivic Genosa failed to prove that she is afflicted with the battered woman syndrome, BWS. The defense fell short of proving all three phases of the cycle of violence supposedly characterizing the relationship of Ben and Marivic Genosa. No doubt there were acute battering incidents, but appellant failed to prove that in at least another battering episode in the past, she had gone through a similar pattern. Neither did appellant proffer sufficient evidence in regard to the third phase of the cycle. In any event, the existence of the syndrome in a relationship does not in itself establish the legal right of the woman to kill her abusive partner. Evidence must still be considered in the context of self-defense. Settled in our jurisprudence is the rule that the one who resorts to self-defense must face a real threat on one's life, and the peril sought to be avoided must be imminent and actual, not merely imaginary. 8. Calalang v. William 70 Phil 726, 1940. This 1940 case is known primarily for Justice Jose P. Laurel's definition of social justice. Social justice is neither communism, nor despotism, nor atomism, nor anarchy, but the humanization of laws and the equalization of social and economic forces by the state so that justice in its rational and objectively secular conception may at least be approximated. Social justice means the promotion of the welfare of all the people, the adoption by the government of measures calculated to ensure economic stability of all the competent elements of society, through the maintenance of a proper economic and social equilibrium in the interrelations of the members of the community, constitutionally, through the adoption of measures legally justifiable, or extra-constitutionally, through the exercise of powers underlying the existence of all governments on the time-honored principle of salus populi est supremo, lex. Social justice, therefore, must be founded on the recognition of the necessity of interdependence among diverse units of a society and of the protection that should be equally and evenly extended to all groups as a combined force in our social and economic life, consistent with the fundamental and paramount objective of the state of promoting the health, comfort, and quiet of all persons, and of bringing about the greatest good to the greatest number. 9. Chuakwa v. Clave Gr. No. L49549 August 30, 1990. A truly remarkable case wherein the Supreme Court ruled in favor of love. The setting of the case was in when marriage between minors was still legal, way before the family code. In this case, a 30-year-old teacher had married her student, which prompted the school to terminate her. And against all odds the Supreme Court ruled in favor of her, hence, creating this landmark case. If the two eventually fell in love, despite the disparity in their ages and academic levels, this only lends substance to the truism that the heart has reasons of its own which reason does not know. 10. Oposa vs. Factoran Gr. No. 101083 July 30, 1993. The case focuses on one specific fundamental legal right, the right to a balanced and healthful ecology which, for the first time in our nation's constitutional history, is solemnly incorporated in the fundamental law. The right to a balanced and healthful ecology carries with it the correlative duty to refrain from impairing the environment. Thus, the right of the petitioners, and all those they represent, to a balanced and healthful ecology is as clear as the DENR's duty, under its mandate and by virtue of its powers and functions under EO number 192 and the Administrative Code of 1987, to protect and advance the said right.